Today, we're going to be discussing another motion that was filed in the Sarah Boone case. Now, this is not a motion that was filed by the defense for Sarah Boone. Those are the past few motions which we analyzed. And if you haven't seen those, go check those out in my last few videos on Sarah Boone, which discuss those two motions. Number one, the motion to suppress the 2-hour interrogation. And number two, the motion for Sarah Boone to have a professional hairstylist and to have access to makeup during the trial. We discussed those in previous videos. Today's motion is actually a motion that was filed by the state. This is what we would call a preemptive motion. It's a preemptive motion because the state is anticipating that the defense is going to make an argument, whether written or oral, that the body cam footage of the responding police officers when they first made contact and had interactions and conversations with Sarah Boone, they're anticipating that the defense is going to move to suppress those videos. So that is what we are going to be discussing today. So again, the state is essentially asking the judge, in case the defense is going to make some sort of motion that body cam footage should be suppressed and excluded, we are asking that you deny that right now off the bat. So let's jump into that motion. It's a short motion, but actually it brings down a very important case, and it discusses a very important case in Florida. And that's why I think it's important to actually look into that case, do some research on the case, which is what we do on this channel. We don't just report and read motions for you. We actually do some of the research. And it's important if you're going to be following a lot of these Florida cases that may implicate a very similar type of arguments that have to do with Miranda warnings and things like that. So that's why I think it's important anyway to get a good understanding of this case that we're going to be discussing today. But first, let's bring up the motion and let's go through the motion. It's a very short motion, but again, it brings down this very important case. All right, here we go. Deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 p.m. on February 24th, 2020, responded to the defendant's residence. Number two, Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings. One begins at approximately 1:08 p.m. and lasts 13 minutes and 32 seconds. The next starts at approximately 1:22 p.m. and lasts 4 minutes and 56 seconds. The final one starts at approximately 1:30 p.m. and lasts 5 minutes and 30 seconds. At no time was the defendant in anything that resembles custody for Miranda purposes. Now let's stop right there. What does that mean, custody, and what does it have to do with Miranda? Well, we've kind of explained this in our previous videos, but again, this is how it works. Miranda is only triggered if there is an interrogation which is done when a defendant is in custody. We call it a custodial interrogation. So again, the defendant has to be, number one, in custody. Number two is that there has to be an interrogation. So those are 2 separate things that have to occur in order for your Miranda rights to be triggered, and that the police have to read you your Miranda warnings and get a waiver from you if you so choose to continue talking to them. Okay, so here the state is saying that at no time was the defendant in anything that resembles custody for Miranda purposes. And what do they cite here? They cite Ramirez versus State. So we can see what the state is about to say about Ramirez versus State and what they believe the holding is. But if we really want to be honest, especially honest lawyers who are analyzing this, what we'll do is we'll simply copy and paste this case, this site right here, put it into Google and look up the case. So that is exactly what we're going to do. That's what we do on this channel. We actually analyze it. So today you get to actually get a closer look at what the work that I do in order to bring you this analysis. So let's bring up that case. All right. So this is the case of Ramirez versus State, as you see up here, Ramirez versus State. And it's a longer opinion. It has to do with a number of different issues. And that's what happens a lot of times on these opinions, or in these opinions. They talk about a lot of issues that really are not relevant to the specific issue that you're dealing with. So you have to kind of figure out what part of the opinion is relevant to the discussion that we're having about this motion, or what the motion is seeking. So that's just one of the works that you have to do. So here it's pretty clear. Suppression of the confession is obviously going to be the issue here. So let's let's jump into it from here. And this is what it says. Both prior to and during the trial, Ramirez moved to suppress his confession. So in this case, we're going to see some of the details very soon. But Ramirez eventually, this defendant, Ramirez, he confessed essentially to the crimes that he committed, and they want to now suppress his confession. So the trial court denied both motions, and the confession was introduced as substantive evidence against him. And when the jury hears a confession, what are they going to do? They're going to convict. The pertinent facts surrounding the confession follow. So these are the facts of the case. They're pretty gruesome, and therefore, if you get sensitive from these facts, then you should probably turn this off now. But you have to read this if you want to actually understand the law as it relates to this specific issue. So here we go. The victim's body was found in an open field not far from her home. Her death was caused by 2 gunshot wounds to the head. So this is a woman who was the victim. She was shot in the head twice, and she was found in an open field. The subsequent investigation revealed that someone had broken into her home and stolen some items of jewelry, her gun, and about $35. There was evidence that the victim had been raped before her death. So a gruesome, horrific, terrible way of this poor woman dying, that she was raped, she was burglarized, and then she was taken to an open field and shot in the head. So really, really terrible, tragic story. And Ramirez is one of the defendants. But there's another defendant here, and his name is Grimshaw. So Grimshaw, who was the victim's neighbor, soon became a suspect. After several interviews and a final interrogation lasting several hours, Grimshaw confessed his involvement in the crime. So after a lengthy interrogation and interviews, Grimshaw, who was the co-defendant in this case, confessed that he was involved with this murder. Although Grimshaw gave several inconsistent versions of the events, he eventually admitted his involvement in the crime, but pointed to Ramirez, who is the defendant in this case and who's filing this appeal, but pointed to Ramirez as the ringleader. Now, Ramirez, just a little bit more background information, Ramirez found guilty and he was sentenced to death. So this is an appeal to save him from the death penalty and to get him a new trial. So Grimshaw, again, is the co-defendant. He points the finger to Ramirez, that Ramirez is the ringleader. In order to convince the police of the truthfulness of his statements regarding Ramirez's involvement, Grimshaw phoned Ramirez from the station while the sheriff's detectives listened in and recorded the call. So what happened here is Grimshaw is at the police station and he's trying to convince the police that really it was all Ramirez and he was just acting at the behest of Ramirez. And in order to prove that, Grimshaw called Ramirez and pretended to speak to him openly like nothing's going on. And in the meantime, the detectives are listening in and recording the phone call. During the call, Ramirez and Grimshaw discussed the items of physical evidence related to the crime that were in Ramirez's possession. So they're actually talking about the evidence that connects Ramirez and Grimshaw to the actual murder. And they're talking about, well, what should we do with these items? Should we destroy them? Should we burn them? It sounds like they're having some sort of conversation about it. And they made plans to destroy the victim's automobile to eliminate evidence of the crime. All right, so the detectives hear all this. What do they do? What do you think they do? They go to arrest Ramirez. Well, first, this is what they do. Ramirez was at home around 3 o'clock that afternoon when shortly after the phone call, a sheriff's deputy arrived wearing a badge and carrying a firearm. The deputy asked Ramirez to produce the physical evidence in his possession linked to the murder, including the suspected murder weapon and some of the victim's jewelry. According to the deputy, Ramirez was a little hesitant at first and denied having the article. So first, Ramirez says, I don't know what you're talking about. After the deputy informed Ramirez that he knew about the phone conversation with Grimshaw, so the police says, listen, buddy, I was listening to that conversation. All right, I know what you have. So after he told Ramirez that, what do you think happened? Ramirez turned over the items that were in the house and accompanied the deputy to retrieve other items. The deputy then asked Ramirez if he would be willing to come with him to the sheriff's office to speak with a detective. Once transported to the station, Ramirez was placed in a small room and questioned by 2 other detectives. The entire interrogation at the station was videotaped and is part of the record on appeal. The videotape reveals that the lead detective began the interrogation by questioning Ramirez about how the items came into his possession. When Ramirez initially claimed that Grimshaw gave him the items, one of the detectives informed Ramirez that, and this is what the detective actually says verbatim, resources indicate that you may have some involvement in the case. What I want you to do is I want you to be honest with me. The indication we have is that both you and John, meaning Grimshaw, are involved. I want you to tell me what happened that night. I know you were there. I wouldn't be here if I didn't know that. You know what I'm saying? So that is exactly what the detective tells Ramirez while he's talking to him. After these statements by the detective, Ramirez admitted breaking into the victim's house the night of the murder. It was only after this admission that the second detective suggested that Ramirez be informed of his Miranda rights. So this entire conversation that happened before that at the police station, Ramirez was not read his Miranda rights. And only after he admitted that he broke into the victim's house that night, then the detective decided to read him his Miranda rights. And this is what the detective said. The detective said, "Why don't you let Nate, who is Ramirez's first name, know about his rights? I mean, he's already told us about going in the house and whatever. I don't think that's going to change Nate's desire to cooperate with us." And we're going to see that that's kind of belittling the Miranda warnings and rights that a person has. And that's also a big no-no. And we're not going to really get into that too much because it doesn't really have so much to do with our issue in front of us. Ramirez then asked if he was like being placed under arrest, to which the other detective responded, No, I'm just reading your rights at this time." After the Miranda rights were administered, Ramirez acknowledged what the detective had read by nodding and stating, "I guess that is what I'm here for." Ramirez eventually admitted his involvement not only in the burglary, but also in the murder. He stated that he was the one who shot the victim, denied any involvement in the rape, and claimed that he was acting at Grimshaw's direction. Only after Ramirez fully confessed to the murder did the detectives belatedly obtain a written waiver of his Miranda rights. When Ramirez was asked to sign the waiver of rights form after he had fully confessed, the lead detective asked him to acknowledge that he had not been promised anything or been threatened before giving his statement. Ramirez's response was that the detective had only promised to be his friend. All right, so those are the facts of this case of Ramirez. All right, so that's essentially the story. And now the Supreme Court, the Florida Supreme Court, is going to analyze the law. Now that we know the facts, now let's analyze those facts under the law. So here we go. Both the United States and Florida constitutions provide that persons shall not be compelled to be witnesses against themselves in any criminal matter. That we know you cannot. It's the Fifth Amendment. This constitutional guarantee is fully applicable during a period of what? Custodial interrogation. And that's a direct quote from Miranda versus Arizona. Miranda versus Arizona. That's where Miranda rights come from this case. So again, the constitutional guarantee that you're not going to be a witness against yourself is fully applicable during a period of custodial interrogation. Thus, to be admissible in a criminal trial, the state must prove that the confession was not compelled, but was voluntarily made. In Miranda, the United States Supreme Court enunciated a bright-line rule to guard against compulsion and the coercive nature and atmosphere of custodial interrogation and assure that the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. Miranda requires that police inform suspects that they have the right to remain silent and that anything they do, yada, 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 we know already what Miranda requires you to do. So now let's continue. Ramirez argues that the requirements of Miranda were violated because the warnings were not administered before the interrogation began, rendering his confession to the crime inadmissible. So this is exactly Ramirez's argument, that Miranda required the police to issue these warnings, tell him about his Miranda rights before the interrogation began, not after he admitted to breaking into this victim's house. And when does interrogation take place? Well, interrogation takes place when a person is subjected to express questions or other words or actions by a state agent, meaning the police, that a reasonable person would conclude are designed to lead to an incriminating response. So what's an interrogation? An interrogation is not just simply gathering information. An interrogation are questions, express questions, or other words or actions taken by a police which a reasonable person would conclude are trying to lead the person to give an incriminating response. That is what an interrogation is. There is no question in this case that Ramirez was subjected to interrogation and was not initially informed of his Miranda rights. However, let's stop it right there. Understanding what we've read up until now, now that there is an interrogation, that definitely Ramirez was the subject of an interrogation, well, he was not read his Miranda rights. So very clearly there was a Miranda violation, right? No. Why? Because the state argues that Miranda warnings were not required because Ramirez was not in custody at the time that he was interrogated at the police station. So remember, those are the two important parts. Interrogation, that's number one, that this has to be considered an interrogation, but also that the person has to be considered in custody. And here was Ramirez considered to be in custody? So the state argues that no, he wasn't in custody. He wasn't under arrest yet. So this was not custody at all. So you're right, it was an interrogation, but you need two things. You need it in custody and an interrogation. So let's see if the Florida Supreme Court agrees with the state. Again, however, the state argues that Miranda warnings were not required because Ramirez was not in custody at the time that he was interrogated at the police station. We disagree. So the Florida Supreme Court disagrees with the state. Now, why is that? Why do they disagree? Well, you have to get kind of given the definition of what is considered to be in custody and what's not. That's what you have to do if you're the Florida Supreme Court. And guess what? They know what to do, and they're about to give definitions of what's considered custody for Miranda purposes. So here we go. Custody for purposes of Miranda encompasses not only formal arrest, but any restraint on freedom of movement of the degree associated with formal arrest. So it's not just a formal arrest. You are hereby under arrest. Let me put you in handcuffs. No, that doesn't mean that's the only thing that what constitutes custody. Custody means that you do not have the freedom to move to the same degree as a formal arrest. All right. So again, this is still a little bit of an abstract idea, and they're going to explain more. Luckily, a person is in custody if a reasonable person placed in the same position would believe that his or her freedom of action was curtailed to a degree associated with actual arrest. Okay, that doesn't really help us too much either. The proper inquiry is not that the unarticulated plan of the police, but rather how a reasonable person in the suspect's position would have perceived the situation. Meaning it doesn't depend on what the police's plan here is. The question is only from the perspective of the defendant. If a reasonable person was in the defendant's position, would he have perceived that he is in custody? Not what the police think, but what he would have perceived in his situation. So here we go. The question of whether a suspect is in custody is a mixed question of law and fact. See Thompson versus Kohana. The four-factor test adopted by the Iowa Supreme Court provides guidance in making the determination whether a reasonable person in the suspect's position would consider himself in custody. So a lot of times you have one jurisdiction which is borrowing ideas from other jurisdictions. So here you have the Florida Supreme Court who's borrowing essentially this four-factor test, which was adopted by the Iowa Supreme Court to decide whether a person is considered in custody. Would a reasonable person in a situation be considered in custody? Would he consider himself in custody? Then you analyze it through these four factors. So here are the four factors. Number one, the manner in which police summon the suspect for questioning. So is it a situation where the police are telling you, you have to come down to the station? We want you to come down to the station. We want you to come in our police car. We want you to be coming to an interrogation room. That is the first factor, the manner in which the police summon the suspect for questioning, or was actually the defendant was the one who called the police. So that's also going to make a difference. So that's factor number one, the manner in which the police summon the suspect for questioning. Number two, the purpose, place, and manner of the interrogation. So now actually moving on to the actual interrogation. What is the purpose of this interrogation? Why are the police talking to this individual? What are they trying to gain? Are they just trying to get information? Are they just trying to figure out what happened? Or they're actually trying to figure out whether this person was involved. And that's why that's the purpose of this interrogation. That's an important part. The place of the interrogation. Where is this interrogation occurring? Again, is it occurring in the police station, in the car, in a backyard, in front of the person's residence? Where is it happening? And the manner of interrogation. What are the techniques that are being used? Are they trying to be sneaky? Are they using these interrogation techniques that they're taught to get admissions or confessions? What's the manner? Or is the manner just simply open up the questions? What happened here? What's going on? I'm trying to figure this out. That's also an important part. Okay, number three, the extent to which the suspect is confronted with evidence of his or her guilt. So at any point in time during this interrogation, is the defendant actually confronted with, here, we've got your DNA on the murder weapon? Well, now that certainly looks like an interrogation. Then a person can feel that, hey, this is probably custody. I'm probably not going free today. So that's another factor. And number four, whether the suspect is informed that he or she is free to leave the place of questioning. So actually just letting the person know you're free to go. You should just or I'm letting you know that you're always free to go. We don't have to talk to me. So that's another factor. Now those were the factors in the Iowa Supreme Court. what about Florida? So now is a Florida saying that we're adopting this four-factor test? Not exactly, but essentially. So look what it says. Although not set forth as a four-factor test, our case law, meaning in Florida, includes a consideration of these same factors. So if you look at these cases, Castle versus State, Roman case, Drake versus State, these cases all stand, and they basically accept this four factors as the same way to analyze whether someone's considered in custody or not. They just may not say we have a four-factor test, but they essentially take these same factors into consideration. So now we have to take these four factors and figure out whether in Ramirez's case he was considered, would a reasonable person consider themselves in custody? Well, here we go. Considering these factors, it is uncontroverted that by the time the detective came to Ramirez's home to request that he turn over the items of physical evidence related to the crime, Grimshaw had implicated Ramirez as a principal in the murder. So when the police are going over there, what's in their thought process? They're just trying to gather information? They're just trying to get some evidence? Or Grimshaw already told them that Ramirez is really a serious suspect in this case? So obviously the latter. And the police had listened in on the phone call with Grimshaw, during which Ramirez admitted that he had items of physical evidence directly related to the crime. By the time Ramirez was brought to the police station for questioning, he had in fact turned over that physical evidence. The detectives told Ramirez that they knew he was involved. While the police may not have told Ramirez that he was under arrest, he was never told he was free to leave. They undoubtedly had probable cause to arrest him. The record reflects that Ramirez was a juvenile and had only limited contact with the justice system. We conclude that not only a reasonable juvenile, but even a reasonable adult in Ramirez's position would have believed that he was in custody at the time of the interrogation at the police station. He was questioned in a small room in the police station by two detectives. He was never told he was free to leave, and all of the questions indicated that the detectives considered him a suspect. So the Florida Supreme Court is saying clearly in this case, in Ramirez's case, this was absolutely a custodial interrogation. Okay, there was a purpose. Where was it? It was in the station. The manner of was an interrogation. All of those factors lead you to believe, a reasonable person to believe, that he was in custody. He is not going home, right? So that is what this case stands for. So now that we see what is considered in custody, now we have to take those four factors and apply it to Sarah Boone's case and see whether those factors apply in Sarah Boone's case. And if they do, well, then you can argue that she should have been given her Miranda rights. Well, let's see. So let's go back to the state's motion here. All right, so let's go back. Here we go again. Number 4, at no time was the defendant in anything that resembles custody for Miranda purposes, and they quote Ramirez versus State. The Ramirez case outlines the famous four-factor test, and they actually got it right here. If you go through the four factors, they quoted it exactly correctly. Now, while Deputy Rodriguez would not let the defendant enter the crime scene, the defendant's home, to retrieve a soda or cigarettes, the defendant was not in custody. So again, just because the defendant, in this case, Sarah Boone, was not allowed to go get soda or go get cigarettes from her home, that doesn't mean that she's in custody, because just because she's restricted in some way in a crime scene, that doesn't mean that she's in custody. We just don't want you to mess with the crime scene. And they quote a case here called State versus Rincon. In State versus Rincon, actually, that was a case, and I looked it up, but we're not going to read the whole entire case, because really, like I said, this really all comes down to this case of Ramirez. Ramirez is a very important case in Florida jurisprudence. So this is the Miranda case, Ramirez versus State. So that's really all you have to know. Now, State versus Rincon was a case where the police even put somebody in a deputy vehicle. They put someone in the police car and questioned him there, and that wasn't considered that he was in custody, because they were still trying to figure out information, and the person definitely wasn't a suspect yet, and that was the person who actually called the police to come to him. So there was no Miranda rights that were triggered in that case either. So they're just saying the fact that she was restricted in some way, that you couldn't go retrieve a soda or cigarettes, that doesn't mean that she was considered in custody. Now they do a good job. The state does a good job in showing how in this situation, there is no conceivable way that she was considered in custody. And therefore, if she's not in custody, then her Miranda rights do not trigger. So here we go. The deputy was a first responder trying to gather preliminary information about what might have happened. This was not like Ramirez's case where they knew that Sarah Boone was involved. They just got a phone call from Sarah Boone. That's it. They have a death case they have to investigate. So they're just trying to get information for as much as the deputy knows. Sarah Boone's just a regular witness who just happens to was in a relationship with this person who ended up dead. So she doesn't know anything. She's just trying to gather information. The defendant was spoken to on her porch. So this wasn't that Sarah Boone was called down to the station, that she was picked up, and that she was put in the interrogation room. No, she was spoken to on her porch and sidewalk area just outside of her home. She was not confronted with any evidence. She wasn't confronted with any evidence showing her guilt. She wasn't said, they didn't tell her, that your DNA is all over the decedent or something. Jorge. She was not confronted with any evidence because at that time, there's nothing to confront her with. The defendant was informed she was not free to leave the area due to the investigation, but the restraint on her freedom of movement never resembled custodial arrest. So just because we need you to stay here because we need to talk to you, we need to figure out what's going on here, doesn't mean that you are under custodial arrest. Just under 4 hours later, she was interviewed by Detectives Counsel and Lowen inside an unmarked car on the scene. Although under both Ramirez and Rinkin, this is not custody for purposes of Miranda, she was given her Miranda warnings anyway. So she was given her Miranda's warnings anyway when she was interviewed by Detective Counsel and Lowen inside a unmarked car on the scene. So just to be sure, we did everything so right that we even gave her Miranda warnings when it wasn't even required by us to give the Miranda warnings. So for the reasons outlined in the state's response to the defendant's motion to suppress statements at Orange County Sheriff's Office, the Miranda warnings were not defective and her waiver of Miranda rights were voluntary and her statement was voluntary. Any motion to suppress on these statements would not be granted. So this is their motion. This is the state's motion requesting the judge to preemptively deny any sort of motion to suppress the interrogation video of the arrest, not the arrest even, the interrogation video of I shouldn't say the interrogation video. I should say the body cam footage of that first interaction with Sarah Boone. And again, like the other motions, the state is most likely going to win on this motion as well. Well, that is going to be it for today. We're going to keep following the Sarah Boone case, see if there's any more interesting filings and break those down for you and analyze them and look up some of the case law and go through some of the case law with you. And so you will be in the greatest position to understand everything that's going on. And when this trial goes on as well, we'll be there with you step by step and breaking everything down, hopefully explaining everything, doing some research if we need to. So that's what we do here. Looking forward to the next time. And thank you all for joining. And if you haven't yet, please subscribe and like, and we will see you next time.